Hello everyone, I'm the Mass Analyst. About a week or so ago, I made the first in a series of videos examining the question of whether somebody who's been the victim of an unfair DMCA can file a countersuit against the person who took down their video. Is there any recourse against someone who's filed a blatantly unfair DMCA? If it's obvious that your work fell within fair use, can you countersue? And I looked at Section 512F of the DMCA and how the court in Online Policy Group versus Diebold interpreted it. Now, if you haven't watched that video, or if you need to refresh your memory, I would encourage you to watch it now. The Reader's Digest version of this case is that the court concluded that if the person who filed the DMCA complaint knew or should have known that the use in question fell within fair use, then the person who was the victim of this bad DMCA should be able to get damages back in court. They should have some sort of means to redress the fact that they've had their free speech rights stomped all over. It's important to remember that this decision occurred at the federal district court level. That's the lowest level of the court system. Today I'd like to discuss another case, and it occurred in the Ninth Circuit Court of Appeals. And since this was a Court of Appeals decision, it's going to have a much wider impact than the Diebold decision. And this case is called Rossi versus the Motion Picture Association of America. Now let me fill you in on a few of the details of the case. Michael Rossi owned a website called internetmovies.com. And on that website, he had text saying, join to download full-length movies online now. New movies every month. And he also said, full-length downloadable movies and now downloadable. And it was blatantly obvious, or at least at first glance, that this was a place where you could download movies. Well, somebody from the Motion Picture Association of America stumbled across the site somehow. They looked at it, and they reported back to headquarters, and they filed a DMCA against the site, and the site was taken down. Now, they didn't actually try and download a movie from that site. They just saw the banners saying downloadable movie. They assumed that one could download movies. Oh, one more thing. The site also included pictures, thumbnail sketches, or graphics of MPAA movies. So they assumed that some of the movies downloadable for the site were movies that they represented, that they had the copyright interest in. So they sent a DMCA. The site went down, and Rossi turned around and sued them because of this. Because, in fact, you really couldn't get downloadable movies from that site. I'm not sure what the deal is. I think he probably provided links to a site that you could download movies. I'm not sure, but sounds like it was a little bit of false advertisement to me, or a lot of puffery. But in any case, you couldn't download movies despite the wording on that site. So he filed a counter notice, and he said, hey, you guys at the MPAA, you didn't do enough investigation. You should have known that you couldn't get movies from my site. You should have known that you couldn't use my site to infringe on your copyright, and therefore, because you brought my site down, hey, you got to pay me some damages here. Now, the Recording Industry of America, the Motion Picture Industry, the MPAA, the Motion Picture Association of America, wanted the court to adopt a very different standard. They wanted the court to adopt a subjective standard. What that means is that they had a subjective belief. They believed in their hearts of hearts. They really believed that what they were doing was correct and proper. They believed that people could infringe on their copyright by downloading videos from his site. So they didn't want an objective standard. They wanted a subjective standard. They wanted the judge to rule, yeah, so long as you had a subjective belief, so long as you honestly had that belief, then you're okay, you're cool. Rossi can't successfully sue you for damages. So in order to decide how to interpret the phrase good faith belief, the court looked at other courts and how they interpreted that phrase in other laws that use that phrase. The DMCA is not the only law that uses the good faith belief standard, so the court wanted to see, okay, how do you guys interpret it? And they came away concluding that it was a subjective belief. So long as the people who filed the DMCA complaint really believed that they were correct, really believed that their case had merit, they couldn't be sued, uh, even if the complaint really was unreasonable. And that's how they interpreted it. Now, I'm going to read a few key phrases, a few key passages from the decision. They start out, in 512F, Congress included an expressly limited cause of action for improper infringement notifications, imposing liability only if the copyright owner notification is a knowing misrepresentation. They then note in the footnote what 512F states. It states that any person who knowingly materially misrepresents that material or activity is infringing shall be liable for any damages incurred by the alleged infringer. So the phrase is knowingly, not knowingly or should have known. Okay, then the court continued. A copyright owner cannot be liable simply because an unknowing mistake is made, even if the copyright owner acted unreasonably in making the mistake. Rather, there must be a demonstration of some actual knowledge of misrepresentation on the part of the copyright owner. Juxtaposing the good faith proviso of the DMCA with the knowing misrepresentation provision of the same statute reveals an apparent statutory structure that predicated the imposition of liability upon copyright owners only for knowing misrepresentations regarding allegedly infringing websites. Measuring compliance with a lesser objective reasonableness standard would be inconsistent with Congress's apparent intent that the statute protect potential violators from subjectively improper actions by copyright owners. Okay, that's a lot of legalese gobbledygook, I admit. What they were saying really is that Congress intended the statute to protect copyright owners. If copyright owners became gun shy, if they became too afraid to file notices unless they were absolutely 100% certain that their notices had merits, then a lot of notices wouldn't be filed, and a lot of copyright where they could well have been filed, and a lot of copyright owners would end up being hurt in the process if they were reluctant to file to protect their property interests because they were afraid that this could come back and bite them. So this was clearly a decision on the side of copyright owners. So that's what the court decided. Now, what do I think of what the court decided? Well, if I could talk to the judge who decided Rossi, I'd say, "Are you nuts? Think about it, man. Think. Use your head. Think. Are you really saying that just because someone believes that they're right, that they have absolutely no obligation whatsoever to conduct even a cursory investigation to see whether their complaint has merit? What happens if the guy's a true fruitcake? I mean, what if he's working with his Ouija board one day and he's moving the letters around or whatever and he gets, the feeling, the spirits from above are telling me that your video infringes upon my copyright. The spirits from above inform me and I must obey the spirits from above. One cannot question the spirits from above. Doing so would be sacrilege. And so I must obey the spirits above. And I must file that DMCA against your video because they tell me that you're violating my copyright. And I'm not going to investigate. I'm not even going to look at your video. I sincerely believe in my heart of hearts that your video is infringing. Are you going to tell me, Your Honor, that in such a situation, such a ridiculous situation, that the clown who files a DMCA doesn't have any obligations whatsoever to do a reasonable inquiry? And if you're going to tell me that, Your Honor, then please tell me, why didn't you even begin to discuss in your decision DMCA Rule 512C36? You totally ignored it. Now, I imagine some of you are asking, 512.3c6? What does that say, Master Analyst? Why would you be asking the judge about that? Well, 512c36 states that the complaint must include a statement that the information in the notification is accurate and under penalty of perjury that the complaining party is authorized to act on behalf of the owner of an exclusive right that is allegedly infringed. Now think about it. It requires a statement that the information in the notification is accurate. Now, why would Congress include a requirement that you sign off that the information in the notification is accurate unless they wanted you to at least do a little bit of investigation as to whether or not it was accurate? Unless they wanted to make sure that you weren't totally negligent in your filing of the complaint. Why would they include that requirement? And part of the information that the DMCA requires is that you state that the video or the material infringes upon your work, that it infringes upon what you have done. Now, Section 107 of the Copyright Act of the U.S. Code says that fair use of a copyrighted work is not an infringement of copyright. Let me repeat that. Fair use is not an infringement of copyright. So here we have on the Congress saying on the one hand that you have to sign a statement that your DMCA complaint is accurate, and the DMCA complaint states that the work is infringing upon your work, and Congress has also passed a law stating that if it falls within fair use, it's not an infringement. Therefore, the only reasonable way to read 512F, to read the requirement, is that you must at least do a cursory investigation to verify that your complaint is reasonable. There's no other logical way to put this together. But the court didn't even mention this requirement of the DMCA. You can look at the court's order, the order that sets precedent, and that other courts around the country will look toward in their decisions. They're not necessarily going to be bound by this declaration. Only if it goes up to the Supreme Court and is decided that way will all the courts in the country be bound by it. But it's going to be a very influential declaration. And nowhere in the order does it even discuss that requirement. Your Honor, you blew it. And unfortunately, when I discuss the Lens versus Universal Music Group Corporation, the Rossi case figures very prominently in the judge's decision in that case. Well, this has been the Masked Analyst, under an N.